Okay, so welcome again to the series of lectures of Basic Philippine Law and Jurisprudence, the series of lectures on persons and family relations. So our topic for today is donations by reason of marriage. Okay. Article 82 tells us what is meant by donations by reason of marriage. Okay, donations by reason of marriage is one which is made by reason of the marriage. So the primary consideration of a donation propter nuptias is the marriage. Okay? And it is made in favor of one or both spouses. Okay. Now, the law which governs donations propter nuptias is the rules on ordinary donations as established in the Civil Code insofar as they are not modified by the following articles. So if there is the primary law that governs donations by reason of marriage are articles 82 to 87 of the Family Code. Okay. However, the provisions of the Civil Code on donations will apply in a suppletory manner. Okay. Uh, there is a prohibition for the spouses, okay, to donate more than one-fifth of their present property. Okay, if they will be governed by marriage settlements other than absolute community. So if, for example, the spouses agree on a marriage settlement such as conjugal partnership of gains or separation of property or other regimes which is a combination of absolute community and conjugal or any other regime which is made or crafted by the spouses themselves, they cannot donate to each other, okay, more than one-fifth of their present property. However, if, for example, they have not entered into any property regime, okay, then automatic the default property regime of absolute community will govern their property relations. So in that case, there is the prohibition on donation to each other of more than one-fifth of their present property will not apply. Why? Because when you have absolute community of property, all of your properties before you got married, the respective properties of the spouses before they got married will be placed in one basket, the basket of absolute community property. Okay, so it doesn't really matter if they donated to each other even their entire properties because anyway, they will be placed in one basket. Okay, so what is, in other words, the spouses, the properties of the spouses will be one. Okay, so there is no more distinction once there is absolute community. Okay, there is no more distinction between the properties which were acquired by the spouses before they got married. Okay, so the prohibition on donation of more than one-fifth of present properties of the spouses will apply only if they have agreed on a property regime which is other than absolute community, such as conjugal partnership, separation of property, or any of the combination of the property regimes. Okay. Article 85 tells us that donations by reason of marriage of property subject to encumbrances shall be valid. So if, for example, a property is still subject to a mortgage, does it mean that if it is donated to the spouses, the donation will be considered void? The answer is no. Even if the property is encumbered, okay, can still be donated. However, the property will still be subjected to the same encumbrance. So in case of foreclosure and the property is sold for less than the total amount of the obligation secured, the donee will not be liable for the deficient. Okay, if the property is sold for more than the total amount of the obligation, the donee shall be entitled to the excess. Okay. Article 86 tells us the grounds for the dissolution of donations by reason of marriage. These grounds are exclusive. Okay, meaning if it is not one of the grounds for revocation, you cannot revoke it. Okay, so the ground for the revocation must be within any of those enumerated in Article 86. What are those? If the marriage is not celebrated or judicially declared void ab initio. So you can revoke a donation by reason of marriage if the marriage is not did not happen. Why? Because donations by reason of marriage was made by reason of the marriage. So if there is no marriage, there should be no donation. Okay? Or if the marriage was judicially declared void ab initio. Because that is the consequence of a declaration of a void ab initio marriage. It is as if the marriage did not happen. There was no marriage that happened. And therefore, if there is no marriage, the donation consequently, okay, may be revoked or declared void. Okay. When the marriage takes place without the consent of the parents or guardian, as required by law. Okay. 3, when the marriage is annulled and the donee acted in bad faith. So, for example, there was fraud. So the marriage was subsequently declared annulled by a competent court, and the one who received the donation was the one who acted in bad faith or the one who employed the fraud. Okay? Upon legal separation, the donee being the guilty spouse. Okay? If it is with a resolutory condition and the condition is complied with. Example, if for example there was a donation by reason of marriage, but with a resolutory condition that if the spouses separate, in fact, then the donation shall be considered void. So that is a resolutory condition. So that can be a ground for revocation of the donation. Okay, and last ground, when the donee has committed an act of ingratitude specified by the provisions of the Civil Code on donations. We will study that later in property. Example, an attempt on the life of the donee, for example, of the donor, I mean. Okay, that is an act of ingratitude or a refusal to support the donor whenever he needs it. Okay, and the donee had the means to support the donor. So if this happens, then it is an act of ingratitude, and it may be a ground for the revocation of the donation by reason of marriage. Okay. Article 87 tells us on another prohibition, okay, regarding donation of property, okay, to the among and between the spouses during the marriage. Before we spoke of a prohibition, okay, regarding donation of properties before the marriage, if your property regime is one which is other than absolute community. On the other hand, Article 87 tells us of a prohibition on donations of properties to each other, okay, by the spouses during the marriage. Okay. That article tells us that every donation or grant of gratuitous advantage, direct or indirect, between the spouses during the marriage shall be void except moderate gifts, which the spouses may give each other on the occasion of family rejoicing. The prohibition shall also apply to persons living together as husband and wife without a valid marriage. What is the reason for that? The reason for that is first, to avoid the stronger spouse from taking advantage of the weaker spouse. Second would be to protect creditors because in order to avoid payment, for example, of debts or loans or other obligations, the one of the spouses can donate his or her properties to the other spouse in order to avoid uh, the said obligations. And this prohibition will also apply to persons living together without a valid marriage. So common law spouses are also covered by the prohibition. Okay. The common question that is encountered is whether or not wedding gifts are equivalent to donations by reason of merit. The answer is no. Why? Because donations propter nuptias has several legal requirements for it to be considered as a donation by reason of marriage. What are those? First, it must be made before the celebration of the marriage. This is very important. Okay. The donation must be given before the marriage, but in consideration of the marriage. Okay? It must be made in favor of one or both future spouses. It must be in a public instrument. And it must be accepted by the donor. Donations propter nuptias are wedding gifts, but not all wedding gifts are donations propter nuptias. Because wedding gifts may be given after the celebration of the marriage. So the crucial thing to determine whether it is a donation by reason of marriage or a simple wedding gift is the time when the said donation was given. If it is before the celebration of the marriage and it was contained in a public instrument, then it can be considered as a donation propter nuptias. However, if it is given after the couple has already exchanged wedding vows and during the reception ceremony, then it can be considered as a wedding gift but not a donation propter nuptias. Okay? In the revocation of donations by reason of marriage, is there a need to file an action in court? The answer is yes. Okay, it is not automatic, meaning if the ground exists, for example, if there is legal separation and the donee is the guilty spouse, okay, does it mean that if the couple had legally separated and the person to whom the donation was made is the one who is guilty of the legal separation, does it mean that the donation is automatically revoked? The answer is no. Okay, the donation propter nuptias is not automatically revoked. There is a need to file a court action for revocation. Donation between spouses. As I have said a while ago, there is a prohibition in order to protect the weaker spouse from the stronger spouse and to prevent the indirect violation on the prohibition to modify property regimes during the marriage. Okay, we have the case of Araba versus Tabangkur. So in this case, the property that is involved was there was a deed of donation inter vivos of a certain lot consisting of 150 square meters. Now, respondent filed a complaint for the declaration of the nullity of the said deed of donation. Okay? Respondents who are Francisco's nephews and nieces and his heirs by intestate succession alleged that Cirila was the common law wife of Francisco, and the donation was made by Francisco in her favor. So remember that the prohibition on donations between spouses during the marriage also applies to common law spouses. So in this case, they were contesting the donation because according to the respondents, it was made in favor of the common law spouse. Okay, so what did the Supreme Court said? Their public conduct indicated that theirs was not just a relationship of a caregiver and a patient, but that of exclusive partners akin to husband and wife. Having proven by preponderance of evidence that Cirila and Francisco lived together as husband and wife without a valid marriage, the inescapable conclusion is that the donation made by Francisco in favor of Cirila is void under Article 87 of the Family Code. Okay, the next case is Velasquez versus Court of Appeals. Spouses Aquino were childless. Okay, so spouses Aquino had 6 parcels of land. Now, petitioners, heirs of Velasquez, because of his refusal to partition the conjugal properties of Aquino, petitioners allege that during the lifetime of the spouses Aquino, they had already disposed of their properties in favor of Velasquez. Okay, so the reason for the repudiation of the deed that the Aquino spouses did not intend to give away all their properties since Natalia had several children to support is not one of the grounds for revocation of the donation. So the Velasquez case talks about the exclusivity of the grounds for revocation of a donation propter nuptias. So the ground which is being invoked here is inofficiousness, meaning he cannot dispose of said property to the prejudice of the other compulsory heirs. So you cannot just give your entire property to only one of the heirs, okay, because it will prejudice the legitimes of the other compulsory heirs. But inofficiousness is not one of those grounds for revocation of donations propter nuptias. Okay, but it is one of the grounds provided under the Civil Code for revocation of donations in general. Okay, Mateo versus Lagua. So in this case, Cipriano was the original registered owner of 3 parcels of land. Now, Cipriano donated the said lots to his son, Alejandro, in consideration of his marriage to Bonifacia. However, the title remained in Cipriano's name. Okay, subsequently, Cipriano executed a deed of sale of the same lot in favor of his younger son, Herbacio, and the title was transferred to his name. Now, Bonifacia filed an action to nullify Hervacio's title. Okay? Donations propter nuptias are without onerous consideration. The marriage being merely the occasion or motive for the donation, not its causa. Being liberalities, they remain subject to reduction for inofficiousness upon the donor's death if they should infringe on the legitime of a forced affair. So, they were saying that even if a donation propter nuptias cannot be revoked, okay, on the ground of inofficiousness, it is still subject to inofficiousness based on the revocation of general donations found in the Civil Code. Okay? Serano versus Solomon. Okay? In this case, Melchor married Alejandria. Okay? Now, on the same day of the marriage, but before they were wed, he executed a deed of donation, donating all his exclusive properties as follows. There is a provision in the deed of donation saying that if God will not bless our union with any child, one half of all my properties, including the properties acquired during our union, will be given to my brothers or sisters or their heirs. If I, the husband, will die before my wife, and if my wife will die before me, one half of all my properties and those acquired by us will be given to those who have reared my wife in token of my love to her. So, less than 9 months after they got married, the wife died without an issue. Now, Estanislao commenced this action to implement the said donation to the effect that if Alejandria died before her husband, Melchor, and left no children, then half of Melchor's properties would be given to those persons who raised and uh, took care of the wife, namely Estanislao. So was the donation considered a donation propter nuptials? The Supreme Court said the deed of donation was executed on the occasion when they got married, but the marriage in itself was not the only consideration under which the terms of the donation would be carried out. The marriage would have to be childless, and one of the spouses would have to die before the other, before the donation would operate. So strictly speaking, the donation may not be regarded as one made in consideration of the marriage. So remember that a donation by reason of marriage, the primary consideration of which is the marriage itself. So considering that in the case of Serrano, it was not only the marriage that was the prime consideration, but the one who took care, the marriage would have to be childless, and the wife must die before the husband, and uh, the properties would have to be donated to the one who reared the wife. Okay? The donation was being made not in favor of the wife, but rather in favor of those who acted as her parents and raised her from girlhood to womanhood in the absence of her father. Okay? So it cannot be considered as a donation propter nuptials. Okay? Lorenzo versus Eustaquio. So in this case, the spouses Gregorio and Regina owned a parcel of land. Okay, they have 3 children. Now the spouses executed a deed of donation propter nuptias in favor of Delphine, donating a carabao and 3 parcels of land in celebration of their marriage. So Delphine and Fortunata immediately accepted the donation and occupied the land. The petitioners presented a deed of succession and adjudication. The said deed stated that the subject land was subdivided into 3 lots. Now, the petitioners claim that the donation propter nuptias is void, for there was no valid acceptance, considering that the spouses Gregorio and Regina donated all their properties to Delphine. It violated also their right to compulsory legitimacy. Donations propter nuptias are those which are made before its celebration in consideration of the marriage and in favor of one or both of the future spouses. A donation propter nuptias must be made in a public instrument in which the property donated must be specifically described. So in this case, the inventario matrimonio in favor of Delphine and Fortunata can be considered void because it was not made in a public instrument. It was not notarized and hence not a public instrument. Okay. However, Even if the donation propter nuptias is void, it can still serve as a legal basis of adverse possession. Okay? So meaning, acquisition not through donation, but through prescription. Okay? So the important thing that the Lorenzo case teaches us is that a donation propter nuptias must be contained in a public instrument for it to be considered as a valid donation propter nuptias. Okay? So that's it for donation propter nuptias. Thank you for listening.